To thank you very much for joining us this afternoon. You'll note when you join the webinar that your audio was automatically muted, but we invite you to still ask questions at any time by entering your questions in the Questions tab on your control panel. My colleagues Ryan and Stefan and I will be monitoring your questions and will also facilitate regular opportunities to ask questions during the session. We want to assure you that we'll stay online as long as necessary at the conclusion of the webinar to ensure that all of your questions have been answered. We will also be providing you with a transcript of all the questions and answers by email in the near future. So before we begin, I'd like to go over a few housekeeping items. You can download the PowerPoint that we'll be presenting today. Just click on the Handouts tab in your control panel and follow the instructions. And also your feedback at the end of the session is very important to us and welcomed. So we ask that you please complete the presentation evaluation that will appear on screen at the conclusion of the session. If you experience any technical difficulties during the session, please contact GoToWebinar Technical Support at 1-833-851-8340. I've also put that information in the chat. We are also recording today's session, so the link to the session will be posted on our website in the near future so that those who are not able to attend will be able to access this important information. And now I'd like to turn over the proceedings to Linda Lacroix, the Director of Investigations and Hearings. Linda?
Good afternoon, everyone. I wanted to take this opportunity to thank you for joining us as we discuss an employer's duty to report, including obligations as they relate to fitness to practice matters on the part of members. In addition, we will provide you with some statistics in relation to board reporting. I would like to introduce our presenters for today. Patrick Winter, Intake and Hearings Officer. Evelyn Liu, Intake Coordinator. Janice Duggan, Manager of Investigations. Bernadette Best, Investigator and Team Lead. Carly Thompson, Investigator. In addition to the refresher on employer reporting obligations, we are also being joined by Saran Ragatan, Policy Analyst with the College's Policy and Research Unit. He will be speaking about recent changes to the Ontario College of Teachers Act that will have an impact on employers. As well, we are being joined by David Tallow, Manager, Projects and Programs with the College's Corporate and Council Services Department. David will be providing an update on the college's therapy and counseling program. College staff will be available at the end of today's webinar to answer any questions that you may have. In addition, the information presented today will also be available on the college's website, as we had mentioned earlier. On that note, let's get started.
Good afternoon, everyone. In the next few slides, we'll set out the statutory framework which governs your reporting duty as the employer to the college, and this is a review of what has already been provided in previous webinars. Your employer reporting duties include an ongoing obligation to provide documentation as well as information to the college within the specified time frame. For some stats, in a typical year, the college will receive about 400 employer reports under Section 43.2 and 43.3 of the Ontario College of Teachers Act. I'll direct your attention to the slides. It states that if you terminate, suspend, or restrict the duties of a college member for reasons of professional misconduct, you must notify the college in writing within 30 days. And you must report this even if the member resigns while you're conducting an investigation or compiling evidence. We all know what constitutes a termination or suspension of a member, but sometimes there's lack of clarity of what constitutes a restriction of duty. So here are some common examples. 1, if you're removing a member from the occasional teacher list. 2, if there's been an administrative transfer of a member to another school for disciplinary reasons. And if you're blocking a member from teaching specific grades or specific courses, etc. We're moving on. Yep. So slide Section 43.3 of the Ontario College of Teachers Act is pretty self-explanatory. It sets out the various scenarios relating to the duty to report as they relate to certain types of criminal charges and convictions. It states that if an employee or former employee, and this language is quite important, we'll circle back to this later, if an employee or former employee is charged with or convicted of a criminal offense involving sexual conduct and minors, or an offense that, in the opinion of the employer yourself, indicates that students may be at risk of harm or injury, then the matter must be reported to the college, again within that 30-day period. Please note that the section is written in such a way that if you're aware of charges or convictions of a former employee, even if the member is no longer working for the board or working for you as the employer, there's still that obligation to report to the college. Section 43.3 also contains what we call a catch-all provision, which basically states that if you're in doubt whether to report to the college, please report it to the college. It states that if a member has engaged in conduct or taken action that, in your opinion as the employer, should be reviewed by a committee of the college, then please submit a report to us. In addition, this is a reminder that you are obligated to provide a copy of your notification letter to the member at the same time that you report this to the college. We have been asked in the past whether we notify employers of public complaints that come in against members, and under the Act, the college is only required to report the outcome of the investigation to you, but in most cases where the matters are fully investigated, we will request information from you as the employer, and in doing so, you will inevitably become aware of public complaints against members at an earlier stage. Section 277.4 of the Education Act states that if you terminate a member's employment following an unsatisfactory TPA or teacher performance appraisal, you must submit a complaint to the college. And this again applies even if the member resigns while they're on review status during the TPA process. Now that we've covered when to submit a report, let's discuss what should an employer report include. Some key information that we're looking for here includes the name and college registration number of the member, a summary of events that has led to the report to us, the specifics of disciplinary action that's taken by the employer, and it's also quite important to provide sufficient details in your report. I'll circle back to the second bullet point where it says summary of event that has led to the report. What we're looking for here is enough information for us to make that initial recommendation whether an investigation at the college is necessary. We're looking for a description of events that has led to the disciplinary action and not necessarily just a form letter to us. And if necessary, we'll follow up with employers to obtain additional information. How to submit a report to the college. There are two ways to submit a report to the college, one via email and two via registered mail. However, now more than ever, because of our limited mail capacity and the fact that registered mail can be slower and less reliable, we would strongly encourage you to submit your employer report to the college via email at ih@oct.ca. Again, that stands for Investigations and Hearings at OCT.ca. I will pass it on to my colleagues at Investigations to walk you through what happens once a file moves forward to Investigations.
If the matter moves forward to Investigations, you will receive a letter and a checklist asking for further information. You're required to provide the college with all documentation relating to your report within 30 days of submitting your report to the college. We suggest that you start assembling the information following your report to the college to meet the 30-day timeline. When there are delays with no notice or explanation for the delay provided to the college, or general unresponsiveness, the Director of Investigations and Hearings or the Registrar may contact the Board's Director of Education. Let's do a quick review of the documents required by the college following an employer report. The college requires information and documentation pertaining to a member's previous disciplinary and conduct issues.
What would such information typically include?
Good question. All underlying information and documentation, such as principal, vice principal's notes, witness statements or notes, investigation findings, disciplinary letters, and all relevant email correspondence. The college also requires the member's current employment status, the names, addresses, and contact information for school and board staff who are involved, and those of any affected students and student witnesses are also required. Please do not send redacted documents. If a matter is referred to investigations, the assigned investigator will redact the documents as appropriate before they are disclosed to the member who is the subject of the investigation. For TPA matters, the college will require a copy of all of the most recent summative reports for the member and any materials relating to the TPA process, such as the principal's observation notes. Where there's a criminal matter, the college requires information such as what the member has been charged with and/or found guilty of, or upcoming court dates, and any court documents that you have obtained. Saran will be providing some information about members' new obligations to report criminal matters to the college later on in the presentation. However, the college would still prefer that employers report these matters to us, since not all members may fulfill their reporting obligations. You may wish to go to the employers area or the portal on the college website that provides further information concerning board obligations. Also, most of you should be aware of our checklist that you receive, which sets out what documentation the college is requesting from you. If you are not familiar with the checklist, please send us a note in the questions tab and we will get back to you with this information.
Hi, and I'm just going to chime in at this point to say that when you receive the checklist, we ask for the member's board discipline history. Historically, we have received letters associated with disciplinary measures taken against members. That is helpful, but we would also like to receive any underlying information related to those historic investigations which led to those letters. For example, any meeting or interview notes or statements from students. And again, if the notes are handwritten or illegible, we would also like to receive those in a typewritten form. And the reason for that is it's not just the investigator who will have to review the notes. It'll also be the screening committee, and before the screening committee sees it, it'll also be defense counsel. So if they aren't able to read the materials, that's why we're asking for the typewritten or legible notes. And basically on those previous disciplinary matters, we're asking for the same type of information that we would expect to see when you're making a report to the college under your Section 43 obligation.
Once you have provided all of the information identified in the checklist within the 30-day timeline, the investigator will determine if any additional information is required. As indicated in the slide before you, the legislation requires that such information be provided within 15 days of the employer receiving the request. It is important and appreciated if employers advise if they will be unable to meet the deadline. There may be good reason to request an extension, and the college is open to considering requests. Note that any information that you send to the college as a result of the checklist or as requested by the investigator must also be provided to the member within 30 days of sending it to the college. This is a statutory obligation with which all employers must comply.
We will now address some of the most common questions the college receives regarding our requests for information. Any relevant audio and visual recordings must also be provided. For example, this would include video recordings of a hallway incident. The college also requires any handwritten notes related to the complaint, such as opportunity to respond meetings and interview notes. Prior to commencing an interview, please be sure to include for each set of notes provided, the author of the notes, the full name and title of the individuals present at the meeting or interview, the date and time of the meeting or interview, the location of the meeting or interview, the subject matter of the interview, and please make it clear what incident or incidents you are discussing. Please also identify the date of each incident in question. This includes the month, day, and year. If the reported conduct occurred over a longer time frame, please identify the date as best as you can, or include a broader time period such as in or about the spring of 2019 or in or about March of 2019. And as mentioned, we would appreciate typed notes, or if that is not possible, please ensure legibility. We would also like to take a moment to discuss documents which are sent to us in the form of screenshots. We often receive screenshots of electronic exchanges, for example, email threads or text messages or social media messages, and they have information missing. So please be sure to identify how the screenshot came to your possession. For example, on October 1st, 2018, a student named Jane Doe showed the school principal text messages she exchanged with the member. On October 2nd, 2018, the school principal then took pictures of the screenshots of Jane Doe's phone, which displayed the text messages. Settlement agreements will usually contain a provision indicating that the document can be disclosed if required by law. For example, a legislative requirement, such as that contained in the Ontario College of Teachers Act, is a law that requires this information. You cannot enter into an agreement, including minutes of settlement, with a member, which includes an undertaking that is contrary to your reporting obligations under the Act. For example, you cannot agree not to report a matter to the college that is required under the Act. Also, you cannot agree not to continue to provide information to the college due to the ongoing reporting obligations.
Section 47(1) of the Act permits the college to request personal information about members as defined under provincial and municipal freedom of information legislation. Under Section 48(1) of the Act, the college is required to keep such personal information confidential and not communicate the information to any other person, subject to certain exceptions, including the administration of the Act. We are going to pause here and break for questions. If you have any questions about this reporting obligation, please send them to the questions tab.
Good timing. The one question that was asked has been retracted because you've already answered it.
The Ontario College of Teachers, is there a question, Stefan?
No, I was just going to say, I think you're good to continue.
Okay, thank you. The Ontario College of Teachers Act specifies that the college can require employers to send personal information to the college as defined in MFIPA and FIPA. These two privacy acts define personal information as including information relating to the education or the medical, psychiatric, psychological, criminal, or employment history of the individual, or information relating to financial transactions in which the individual has been involved. Therefore, if you have medical, psychiatric, or psychological reports relating to the concerns which prompted you to notify the college, these must be disclosed as part of your duty to report.
The investigation committee will require medical, psychological, psychiatric information in order to determine whether the matter before it should be referred to the Fitness to Practice Committee. This information may include medical, psychiatric, and psychological reports, as well as any documentation relating to a member's application for short or long-term disability relating to a member's capacity to teach. Should the matter be referred to the Fitness to Practice Committee, it will require the same information in order to determine the matter before it. If you are in doubt whether the member's conduct raises fitness to practice issues, report the conduct as professional misconduct. The investigation committee can always refer the matter to the Fitness to Practice Committee if appropriate. Part of the recent changes to the Ontario College of Teachers Act gives the investigation committee the authority to make inquiries into a member's capacity to teach. If after inquiries, the committee believes on reasonable and probable grounds that the member is incapacitated, it can require the member to attend medical assessments. If the member declines to attend medical assessments, the investigation committee can direct the registrar to suspend the member's certificate until the member complies. In 2019, the college's investigation committee referred 15 matters to the Fitness to Practice Committee. In 2020, it referred 8.
The resource from which this slide and the next slide originates is available by contacting the Manager of Investigations, Janice Duggan, at the college. Her email address will be provided at the end of the presentation. This is a quick reference of do's and don'ts on submitting information to the college regarding matters to incapacity and fitness to practice. I'll give you a few moments to review the do's when submitting information to the college on these matters. And here you'll find a list of items the college requests that you do not do when submitting information to the college on matters related to incapacity and fitness to practice. Again, the PowerPoint presentation will also be made available to you.
When the college requests documents from employers, it's essential that we receive the documents in their truest form without redactions. Oftentimes, we receive employer disclosure packages with student names, ages, and grades or contact information redacted. We also request similar contact information about the parents of the student witnesses if the student witnesses are minors. Please only send unredacted documents. We require this information for the purposes of our investigation. Additionally, the college sometimes receives employer disclosure packages without the student witness contact information. Please ensure it is included in your disclosure package. Some employers have voiced concerns regarding confidentiality over this type of information. We want to assure you that this information remains confidential. However, this information is important for the purposes of our investigation in the event that we need to communicate with student witnesses or their parents. Providing unredacted documents is also important because the college has a disclosure obligation to the member during the investigation process, which allows the member to provide a complete response and full answer in defense to the complaint against him or her. Please be advised that the college does not disclose student witness and/or student victim contact information. However, we do disclose student witness and victim names. When conducting a board investigation, please do not give members and/or witnesses assurances of confidentiality. You will be required to provide the college with all interview notes and contact information as part of your statutory duty of disclosure. As previously stated, the college is obligated to disclose all information to the member during the course of its investigation. Therefore, any assurances of anonymity cannot be given to the alleged victims or witnesses. Also, please do not send password protected documents to the college. The college email system is secure and confidential. And as an aside, the college does not require hard copy disclosure packages. We would prefer to receive an electronic version of the disclosed material.
Please note here again that the timelines specified in the Act remain the same regardless of your academic calendar or closure period.
What about if there's an ongoing grievance or arbitration for the member?
The legislation does not allow the college to delay an investigation when there's an ongoing grievance or arbitration.
All right, we will cover some additional frequently asked questions. The number one being, do I have to report when an employee goes on medical leave of absence? In and of itself, the answer is no. An employer's reporting obligation under Section 43 of the Act are triggered only due to suspension, restriction of duties, or termination of a member for reasons relating to professional misconduct. However, where a member goes on medical leave of absence in the course of an investigation, and you as the employer are uncertain whether the member's conduct would constitute professional misconduct, then please report the matter to the college. The second question, do I have to submit a report to the college when the member is assigned to home pending the outcome of an investigation by the employer? The answer is no, it's not necessary to report that the member has been assigned to home pending an investigation. However, once the investigation concludes and if the member faces a disciplinary restriction of duty, as we have previously discussed, under Section 43.2 of the Act, then the matter must be reported at that time. If an employee goes on medical leave during a board school investigation regarding their conduct, am I required to report this to the college? So in this case, yes, as it may be relevant to how the investigation committee chooses to deal with the member, perhaps they would refer the matter to the Fitness to Practice Committee for fitness concerns.
What is the employer's reporting obligation when a third-party investigator is hired to conduct an investigation of a member? So the college receives an employer notification where a third-party investigator has conducted the investigation. In some of those situations, the employer has entered into an agreement with the third-party investigator that permits the investigator to have ownership of its underlying investigation product. While the employer will provide the third-party investigator's final report, it is not able to provide the underlying investigation materials, for example, the interview notes, because of the agreement signed with the investigator. So the college views these types of agreements as invalid in terms of employer reporting obligations. The employer has an obligation to provide information requested by the registrar. By entering into these agreements, the employer is contracting out of a statutory obligation, which is not permissible. Please consider carefully the implications to your obligation to provide information requested by the registrar when entering into third-party investigation agreements. Now, if you have any questions following the webinar, please feel free to contact Patrick Winter or Janice Duggan, and their contact information is on the screen for you.
Thank you very much to our presenters for all this information. If anyone has any questions that you would like to ask verbally or raise the electronic hand, please do so. We'd love to hear from you. There's also the question tab if you want to type those in. While you're thinking and writing all these questions down, I'll also want to add that to support you moving forward, this PowerPoint presentation can be downloaded. It's in the handout tab on your control panel, and the presentation is also available or will be available on the college website in the near future, as it will be digitally transcribed. Lastly, but most important, we will have an online survey on the GoToMeeting platform. Please complete the survey as your feedback is important to us, and will assist us in planning future webinars. If there are no questions at this time, I would like to turn the presentation over to Saran.
Okay, thanks, Linda. I'll now do a very high level, very brief overview of some of the new amendments that have been introduced into the Act, into our governing legislation, the Ontario College of Teachers Act at the end of last year. It's really represents some of the most significant changes to our governing structure in the college's history, and I'll be giving you that overview of the transition and some other elements that have been previously mentioned. Please feel free to ask questions in the chat, and I'll try and answer them as best as I can. Some of the questions I may not be able to answer, as this is the implementation is in process, but I'll try the best as I can, best I can. So if I could just get to the next slide, please, Liz. Please, thanks. Thanks so much. So the Protect, Support, and Recover from COVID-19 Act, or Bill 229, received royal assent on December 8th of last year. Bill 229 introduced numerous governance reforms, as I mentioned, to the Colleges Act. These governance reforms were largely based on a college-initiated review completed by a governance consultant in November of 2018. The college's governance committee and council reviewed and approved modified versions of the recommendations in the governance consultant's report. I'll flip to the next slide. And we'll go through some of the major elements of the governance reforms. The college will be transitioning from a 37-member council with 23 elected members and 14 publicly appointed members to an 18-member council with 9 college members and 9 non-college members. There will also no longer be an election. A new selection and nominating subcommittee will provide recommendations for council to choose the 9 college members, and the government will choose the other 9 non-college members. Members of council also cannot serve on statutory committees, such as the Investigation, Discipline, and Fitness to Practice committees. The Selection and Nominating Subcommittee will recommend candidates for those committees to council, and the composition will be equal numbers of college and non-college members. So that's a very high-level overview of those governance changes. In terms of the transition, on February 1st of this year, so just a few weeks ago, the governance-related amendments to the Colleges Act took effect, and a transition period officially began with council and committees being dissolved as of this date. Transition Supervisory Officer Paul Boniferro has been appointed to manage the transition, and he has all powers of council during the transition. The college is establishing a roster to help ensure the public protection mandate of the college continues to be fulfilled during the transition. So investigation, discipline proceedings will continue. Regulations and bylaws will also need to be developed or modified to implement the governance reforms. And finally, once a new council and new committees have been established and the various governance reforms have been implemented in accordance with the Act, the transition period and the TSO's appointment will end. So lastly, just covering some of the other amendments that are in Bill 229, so some of these recent changes. Bill 229 introduced new requirements that college members report offenses as well as charges, bail conditions, or other restrictions to the college. So they'll have to include various levels of details, such as the nature of the offense, the relevant court, status of any appeal, many other kind of details that information will be provided about, but just highlighting for you that there are these new reporting obligations, and as was mentioned previously, these are different than your employer reporting requirements that must be made directly to the college. These are reporting requirements for college members to make directly to the college. As a result of Bill 229 amendments, the college has also revoked the certificates of individuals who the discipline committee found to be guilty of an act of professional misconduct consisting of or including sexual abuse of a student or a prohibited act involving child pornography, and did not have their certificates previously revoked. Affected individuals have been sent notices informing them of the revocation of their certificates, and when applicable, school board employers have also been notified. The public register has been updated to reflect these revocations. The Colleges Act has also been amended to include a new mandatory sexual abuse prevention program, which is similar to the program found in the governing legislation for health regulators. This program is will be in effect is in our act as a proposed amendment. The program will include measures aimed at preventing and dealing with sexual abuse of students, and will require education and guidelines for college members, training for college staff, and the provision of information to the public. Discipline committee decisions will also remain permanently available on the college's website. So some of you may have gone to our website and seen our discipline decision list. And in the past, if certain requirements were met, some of those decisions will be pulled off of the website. Now, with the new amendments introduced as a result of Bill 229, all those discipline committee decisions that appear on our website will remain on our website. So they will not be removed. And with that, that is the end of this very high-level overview of the transition that we're currently going in under, and some of the other Bill 229 related amendments. With that, I'll open up there if there are any questions. I don't know if Lee, Stefan, or Ryan saw any questions. If not, we can move over to David's presentation. Okay, so seeing that, I think I'll hand it off to David. Thank you very much.
All right, thanks so much, Saran, and good afternoon, everyone. I'm happy to be carrying the anchor of the relay of presentations we're providing today as well. I'm very happy to be talking to you for the next 5 to 7 minutes about a program that the college has been developing over the last 18 months or so, relating to providing funding for therapy and counseling. My main goal today is to, first of all, make you aware of the program. And my hope is that through your awareness that that's something that could be then sent on to those who may be most in need of access to this. My hope as well is to hear your good ideas and to create a dialogue. We are looking at various ways to improve the information flow about this program and to raise overall sector awareness. And I would be grateful, even were they offline discussions, to continue those conversations and look for opportunities. So let's keep those two pieces in mind as I go through some of the information. And to our next slide, I'll just highlight that since last year, in January 1, 2020, the college has had in effect a program that provides funding for therapy and counseling. And this is something that is now created in our legislation and regulations, and it's fully funded by the college to provide for funding for victims of sexual abuse, child pornography, or prescribed sexual acts by a member of the college. This is a program that's very similar to programs that other health regulated professions offer under their own legislation, and is designed and carried out as a compassionate measure for victims. Jumping to the next slide, the specific funding totals $17,370 that could be accessed or is available to help cover a claimant's costs for therapy and counseling, again, based on allegations made to the college of member sexual abuse, child pornography, or prescribed sexual acts. We have further definition around the acts themselves, and because of how the legislation is written, those would have to have occurred after January 1st, 2020. Jumping to the next slide, that figure that I showed on the screen of $17,370 is available to a individual, a victim, a student victim, or to members of their family. So this could be accessed as a total pool of $17,370 by either the student, their parents, or guardians and or siblings. And the payment and reimbursement of these funds is really administered like many of our health insurance programs, where either reimbursements based on claims could be provided, assuming that those are eligible, or direct funding and payment to a therapist or counselor could be arranged through the program. So there are a few avenues that can be accessed. If a person is approved, the program provides for a range of different reimbursements or payments. First of all, direct costs for therapy or for counseling. As well, prescription drugs or other medicinal substances can be reimbursed through the program. The program also provides for the payment of indirect costs, and these would be costs that are related to obtaining or to seeking therapy and counseling, and could cover everything from transportation, accommodation, meals, childcare, or translation services. And those fall under normal guidelines of reasonable and customary costs. This is a program dealing with the most sensitive subject and those who are in the most need. And for that reason, it's one that we are handling very carefully in the administration, where it is treated very distinct from our work and our administration in dealing with complaints or the prosecution of complaints. And we as a college have established, in everything from designing the program to operating it, established firewalls between the processes. So the files and the management or carriage of any of the reimbursement claims are handled completely separately from the administration of work through investigations and hearings. As well, we do keep information about the specific nature of the claims or reimbursements confidential. The real goal, again, for today is to let you as potential touch points and as staff who may be dealing with students who may be able to avail themselves, to let you know that this exists. And it's really our hope that we could use you as allies and champions of the program to simply direct those who may be able to access it to us through the college's website, through all of the materials that we prepare, and even through just simply dialing into our main switchboard. Anyone who is interested in learning more information about eligibility all the way through to reimbursement of funding for therapy and counseling could be put in touch with the right people. And we hope to be able to get that information out as wide and as broadly as possible. We as an organization really have faced some challenges in getting this information out, simply because in some cases the college may not have direct contact with a student victim, or with their families. So we are, again, looking to allies to be able to share this information and at least be aware that the program exists and is out there. And we hope that within your roles that you could then refer those who may be eligible to the college. All of our contact information, again, is available through the website and in the materials. And we do hope that you'll be able to share this information both within your organization's resources and with any staff who may potentially benefit from being able to share it. I'll pause there to see if there are any questions that are coming in through chat or through our moderator, and just ask Lise if anything is coming in. Okay, and the last piece I would say is this too is something that we hope to use in bettering the program. And if those of you who are working in this area have advice on how to even further reach those potential recipients of funding. Our contact information, again, is available through the materials, and I would love to be able to have those conversations and hear suggestions and good ideas. I will conclude on that note and wish everyone a good afternoon.
Thank you, David. So we'll give it another minute or two. If there are any other questions, please feel free to put them into the chat before we close out the webinar. David, there is a question for you. Have we lost David?
Lise, it seems like David's already signed off. So
Okay.
I guess to answer the question, we can definitely take that back and send you a response, Stephanie.
Thank you, Stefan.
Oh, I do see that David is back on. David, did you want to unmute yourself? There was a question for you.
Oh, thanks very much. And sorry about that, I was just disconnected.
No worries. So the question for you is, school board labor relations staff who investigate sexual misconduct are also in need of support. Would they qualify?
Thanks for the question. And unfortunately, they would not qualify for specific funding under the program. It is very carefully prescribed and laid out in legislation that it would be designed specifically for victims of those prescribed areas or those prescribed acts that I listed, namely sexual abuse, prescribed sexual acts prescribed sexual acts under the legislation and child pornography, and specifically for victims or those members of their family. It's something we've explored the edges of and had similar requests even from members about receiving similar funding, but it is something that is instead very narrowly focused on student victims of those acts by members of the college.
Thank you, David. Okay, I don't see any other questions. So I think we will conclude the webinar for today. Once again, the handouts, the copy of the slideshow is available in the handout section. And as you exit the webinar today, you will be asked to fill out a survey. Please do so. Your feedback is very helpful in helping us plan for future sessions. So thank you again for joining us today, and I hope you enjoy the rest of your day.